in, but I would like us to get started. I'm Stefano Violanos. I'm the director of the Remarque Institute, and I teach in the history department at NYU. And together with Samantha Paul and Amy Nguyen, we'll be hosting you for this event to celebrate Martti Koskenniemi's new history of the legal imagination, called To the Uttermost Parts of the Earth, Legal Imagination and International Power, 1300 to 1870. Let me also acknowledge Karen Levy and the Institute for International Law and Justice for sponsoring this event with us. Now, Martti is, as you most likely know, a former diplomat from Finland and an international lawyer. He's Academy Professor at the University of Helsinki and the director of the Erik Karlsson Institute of International Law and Human Rights. And for 25 years now, actually 25 years now, he has been a global professor of law, visiting every year at NYU. He has held many other appointments, but I'm going to let you find these online rather than list them one by one, because I want to say something else for a second. He's the author of From Apology to Utopia, The Structure of International Legal Argument from 1989, The Politics of International Law from 2011, and of course, of The Gentle Civilizer of Nations, The Rise and Fall of International Law, 1870 to 1960 from 2002. The Gentle Civilizer of Nations won the American Society of International Law Certificate of Merit in 2002, and it was one of the books of the year for the Neue Juristische Wochenschrift in 2002 as well. But more to the point, it became the standard bearer, the criterion really for working on the history of international law. There is no book in the field that compares to it, and there's no book in the field that does not have to contend with it throughout its own argument. On the next to last page, 516, Koskenniemi discusses the way that at the time, let's say in the early 2000s, international law could not, as he puts it, indulge in reveries from the limitations, political and other, that follow from there. Quote, without the ability to articulate political visions and critiques, international law becomes pragmatism all the way down, an all-encompassing internalization, symbol, and reaffirmation of power. But maybe the time of synthesis is not yet here. Maybe it is now a time to listen and to learn. And in the process, one could do worse, still quoting, one could do worse than remember that however one imagines what one is doing and how that relates to other people's being, history has put the international lawyer in a tradition that has thought of itself as the organ of the legal conscience of the civilized world, end quote. So as those 500 pages open the way, he has now written this immense book on legal imagination and power across 6 centuries, and it concerns the language of legal arguments, action, the place of lawyers and law in the making and remaking of statehood, international law, on the place of lawyers and law in the making and remaking of statehood, international orders, and the workings and meanings of power. The angle that concerns power is so intense in this work, precisely because the legal imagination and legal language become here the ground for rethinking modern history and meaning. Now, in Greek, we say megaviglio megakako, which translates as a big book is a great evil. But that this book is long, it's not because he's long-winded. In fact, I found it quite austere, given quite how much he handled. It is because the mutation of languages of law and the political and world-making functions of these languages is so complex. The effect is that we have here a work on power that is a Kantorowicz or Foucault levels of complexity. It is at once thorough, committed to thinking about individuals and about structures, committed to thinking about theology and dynasty and regimes small and larger. Now, I think that the way that we're going to proceed from here is Martti is going to present the book first, and then I've lightly asked 2 Remarque fellows if we have the time, because this might turn out a little bit complicated. Okay, if we have the time, because this might be, here you go, my fault. This might be complicated given on the schedule. If they would say, if they would ask first questions, these are Natasha Wheatley, who's assistant professor at Princeton, and whose book, The Life and Death of States, will be celebrating here about a month from now. It's also forthcoming. And Anna Schultz, who's finishing her PhD at NYU, and he'll be starting as assistant professor at Washington University in St. Louis in the fall. But I do recognize that your schedule is more complicated than we have today. So if that becomes an issue, that's fine. Then we'll open it up, and also to those of you who are on Zoom. I'm going to ask you, Martti, if you can speak up during the presentation, the rest of you as well, because we have to rely in part on the room's microphones, which are both wonderful and no. So with that, I'm taking my leave, and yeah, welcome, Martti.
Okay, I'll speak from here. Thanks for that lovely introduction. I'm really happy to be here. I have two unused US visas because of what happened 2 years ago and what happened last year. So finally I'm here. And I'm also, of course, exceedingly happy that this terrible book is out. It took me 15 years to produce it. A lot of the inspiration behind the book relates to NYU and to New York in various ways. I'm not going to go to any detail about that. So I've already given a book talk on this book a couple of times, so I apologize to those who've been seeing some of bits and pieces on the net. I have this one a slide set that I was thinking about, well, whether should I use it or should I not use it, but it helps me to get through the book. So I'm not going to take it very seriously, but I'm going to use it as a backbone of what I'm going to say more informally to you. The first sentence of the book is, this is not a history of international law. That is based on what I am in record of having written earlier on, namely that international law began in the late 19th century. And this book that Stefanos mentioned, The Gentle Civilizer of Nations, in the various debates where it was engaged, people every now and then asked me, well, Martti, what about Grotius and Vattel and all those people? So one way of thinking of this is that this is an extended response to that query. So it's not a history of international law. Instead, it is a history of various vocabularies through which ambitious men, of course they were all men, European men, tried to deal with problems that they felt were not domestic problems, that were not problems of domestic law. And they engaged in various languages available to them at the time when they were writing. And I try to make, if I can, I'm able to move this. Yes, I think I find. Right. Various vocabularies through which they then addressed those issues, international issues, if you wish. But to use the word international is already a little bit anachronistic. So things that connected with non-domestic affairs. The book doesn't have a heavy methodological introduction, not many fancy footnotes at the beginning, and that's partly because I dislike method as a genre of writing, and also I think it often takes the reader's attention to the wrong place. But I just rapidly say that my view about law is that the power of law is the power of language, and that if you think about law in this way, there are ways in which law and legal language can be discussed and dealt with in the context of human affairs. And I use the notion of bricolage taken from Levi-Strauss, of course, as the kind of operation in which lawyers and other professionals, counsel, theologians, philosophers engage in when they use legal language in order to grasp something that was previously alien to them. Of course, bricolage from Levi-Strauss's various writings has to do with the way in which the indigenous person deals with a new thing that they encounter. They look at things lying around, which is the expression, at least in the English translation, things lying around, combining them then in innovative ways to make sense of this new thing that has emerged. that has been puzzling and to bring it home into a familiar linguistic context. And I suggest that, well, that's what lawyers learn. So legal work is bricolage, and having been a diplomat for almost 20 years, so what is my experience, the most concrete experience I have from working as a lawyer in those circumstances? The concrete experience is that the boss comes in the office, usually very late in the afternoon, and says, Martti, here is a problem. Can you provide a memo until tomorrow at 9 o'clock? And what does one do then? One looks at stuff lying around there in one's memory, on the desk, on the bookshelves, in the net. The time is limited, and you try to construct out of these bits and pieces an argument that provides a response to the boss when they then come in 9 o'clock in the morning. And I look at legal work with legal vocabularies from that perspective in the course of these centuries. And I suggest, also I go very rapidly through this, that the power of law operates in two ways. The legal language frames things to us, just like Hans Holbein's image here framed to Renaissance audiences this picture as obviously having to do with two ambassadors portraying the nature of their business. So law frames the world to us, and in this way makes some things possible and excludes some things from the range of possible. And then a second way in which law works through power, it articulates things as true, as legally true, in the way that other people have to yield to that truth. So that's a very concrete aspect of the power that the lawyer, especially the young lawyer, when they graduate and take up their first job, feel that when they say from their position as experts in law that something is legally true, then other people should yield, and often actually do yield. So those two kinds of ways in which I examine the power of law as language used in the way of bricolage, as I explained. So the book has 12 chapters, which can be divided into two parts broadly. The first 4 chapters lay the ground, if you wish. There is a certain succession there, which starts with the entry of Roman civil lawyers in government service in France at around year 1300. The academic intellectual articulation of what those lawyers did by the Spanish scholastics in the 16th century. The emergence of a rival vocabulary, raison d'etat, ragion di stato, also a legal vocabulary in a Protestant and a Catholic context, as well as the final synthesis of this in the immensely powerful work of Hugo Grotius. I find myself surprised that I'm here to say that Grotius's work is immensely powerful, because so many years I was thinking, oh, it's just hopeless, and he's just all over the place, and there's no real argument here. But actually, I realized he was doing bricolage in order to try to answer a series of pressing questions in the United Provinces in the early 17th century, when there was both civil war, the provinces were in rebellion, and the Vereinigte Ostindische Company, the VOC, was creating the basis for the Dutch Golden Century. So that's, and there is a really powerful idea of the rule of law there. And then the second set of chapters examines various permutations, if you wish, of what had been created in terms of possibilities of legal argumentation in those earlier years. I examine French absolutism in 3 chapters, the way in which French absolutism argues or presents itself abroad, and the way in which it constructs itself in a very non-absolutist way at home. three chapters on England, Britain, both the construction of the specific type of constitutional arrangement of which Britain becomes, and obviously its colonial activities, the legal argumentation behind its colonial activities. The last two substantive chapters on Germany, which really focuses on the German Academy. I'm on record of having written, having said to students many times that international law is a German discipline. I stand by that statement, and I try to give substance to that position then in chapters 11 and 12, which then lead into the epilogue which ends where the gentle civilizer starts, namely where international law is created, modern international law, in 1873, 8th of September, after lunch, with the establishment of the Institut de droit international. Anyway, then I'll just say briefly a few things about this. So the book starts with France, and I was astonished that, well, maybe this is because French lawyers have less interest than we would hope, and we would think that they would have in the early articulation of the constitutional arrangement of the French kings in the late Middle Ages, and where it's clear that the French king Philip the Fair collected around himself a first generation of young German lawyers who had been trained in Orléans and Montpellier, as well as in northern Italian universities. His father and his grandfather had used mostly clergymen as closest advisors. Philip the Fair is really interested in civil law, and he is interested in civil law because civil law has a certain understanding of kingship, namely the understanding which then becomes current in France and with the French relations with the Pope, that the French king is emperor in his real. So for Philip, it's really useful to have a group of experts around him who articulate his position as the position of the emperor, instead of a feudal suzerain, just a particularly powerful feudal lord among other lords. And the expression of sovereignty is now for the first time written in international treaties between Philip and King Edward of England in the settlement of the province of Guyane in France, in a situation where earlier on the relationship between Philip and Edward was between lord and vassal. Now it becomes articulated as a relationship between two sovereign. Well, actually, relationship between a sovereign and a vassal. Edward, of course, doesn't accept this. At the same time as the idea of the royal sovereignty becomes articulated as something else than feudal lordship, the question about what to do with noble properties, and especially landed properties, also properties in Paris very concretely, the properties of the Templar Knights, for instance, emerges. And the late glossators writing early 14th century were clear that the sovereignty that the Roman law provides for the emperor does not reach the private properties of Roman citizens or French citizens. And I quote here Accursius, who in an ironic mode says that, well, the powers of the King of France doesn't mean that he would be the owner of Accursius' property, which leads to the emergence of a series of professional questions about drawing the line between this thing, new thing, sovereignty from an imperial, understood from an imperial perspective, and property understood from the perspective also of Roman law, but also from the perspective of the theology produced by Aquinas, where the rights of private property are a particular type of dominion. What type of dominion it is, I deal with in extenso in Salamanca. And I will, of course, the Salamanca scholars are very famous as originators of something about international legal understanding of the world. And I just briefly mentioned that in this lengthy chapter, I tried to explain how the Salamancans come to the two notions through which they then articulate the position of Charles V, the emperor, as well as of the Spanish nobles, both in relationship to the Indies question, as well as to the expansion of the commercial ethic that is so dangerous for the ideology of the church in this time. And the result here is two types of dominion, dominium jurisdictionis, dominium proprietatis. One of the things I admire among the Salamancans is that their understanding of the king's power over his subjects and the power of the owner towards everybody else is similar. They think of this as a similar kind of a power, dominium, which ultimately reflects the nature of human beings having been created in the image of God, because God is dominus, and our having been created in God's image means we are domini, and our dominium is then articulated in a specific theological political doctrine of dominium jurisdictionis on the one hand, dominium proprietatis on the other hand. The Italian lessons, the third chapter, deals with Alberico Gentili, the now famous civil lawyer, a Protestant refugee in Oxford in the Elizabethan period, and a former Jesuit and a servant of the Pope, and the Pope's ambassador in France during the French religious wars, Giovanni Botero. I was interested in Gentili's work on English kingship in De Potestate Regis Absoluta. He presents a very powerful absolutist view of kingship. He's of course known for international law better as the author of the work De Jure Belli, which is a sprawling work, from which it's hard to find any single perspective other than that he was a civil lawyer and that he was interested in applying Roman civil law in the wars of England, and especially in the efforts of the Elizabethan court to prepare to the coming intervention on the Spanish side. But I don't look at that as much, though that's very familiar, than the use of civil law to buttress the position of King James I, Elizabeth's follower in England, and to expressly make the point that the king has the power to expropriate his subjects also without a cause, which in this genre of writing is a really extremist position. The civil law, earlier civil law writers usually demanded that there be a cause for expropriation and confiscation. With Botero, who I actually appreciate out of these two Italians more, both of them look back, of course, to Machiavelli. Both of them have read Guicciardini, and their understanding of government is very close to Guicciardini's. Both of Gentili openly refers to both Machiavelli and Guicciardini quite often, which gets him into trouble with the Orthodox Protestants in Oxford. As a man of the church, Botero is not able to do that. But Botero's importance is elsewhere. It is in this suggestion that there is this specific kind of knowledge, that is to say, a specific type of vocabulary that has to do with government. And whereas Gentili is an absolutist, Botero is also an absolutist, but actually goes further on in saying how the absolutist rulers should govern, and that they should be very careful about intervening in their subjects' economic activities, because it is through those economic activities that the king, and in his case, the Catholic king, can maintain his regime, threatened as it was in France. So there's Foucault presents Botero as an early mercantilist, and I think that's a fair point to make. For me, what's interesting is that the language of statehood, which then is appropriated by lawyers, becomes here is here expressed so clearly by a Catholic activist clergyman. Grotius. So, and what does Grotius do? The De Jure Belliac Pacis 1625 is a really complex book, and one really has to have patience in order to extract why it would be so significant. But here are three things to which I wanted to draw attention, and in this chapter, in which one is this understanding of human nature. Grotius is, of course, a natural lawyer. Now, a natural lawyer who thinks that law is something that emerges from and is expressed in human nature. And in order to engage in that debate, he has to make a distinction between human nature and animal nature. And in making that distinction, he says that what separates humans from animals is that animals act immediately out of their desire, whereas humans, unlike animals, humans are capable of acting in the same way in respect of things that are alike. In the same way in respect of things that are alike. So humans are human because they are able to follow rules. So this is a hugely significant statement, and it goes through the whole work then. And I realized, for instance, that having read bits and pieces of Grotius and having not really understood what the point is and what the big deal is, it's only once I understood that that the ability to guide one's actions to rules is the essence of being a human being, that the rest opens. But then what are those rules? And Grotius engages in, by now, a reasonably familiar debate on what the meaning of use is that frames the world of rules. And he takes up, like some of the scholastic writers, three meanings of use. Use as justice, use as something towards which just action aspires. That's a teleological Aristotelian understanding. That's an understanding that exists, for example, in the Summa Theologiae of Aquinas. But he doesn't really do anything with it. There's a second understanding of use, he says, which is pretty much the same as a legal enactment. So the king provides an ordinance, that's use. He doesn't do very much with that either. Instead, he concentrates and carries through the book this third understanding, which is at the bottom. Use is a moral quality annexed to the person, enabling him to have or to do something justly. Now, there is, of course, a big debate, has been for a decade or so, on the origin of human rights, subjective rights. This is subjective right, and Grotius carries it to it. This is a right that is enforceable. It's enforceable when it exists or when it has been created, not through enactment by the king, but through commutative relationships of justice, that is to say, contractual relationships. We have rights. Rights are based on contractual relationships. They can be enforced. We also have rights based on distributive relationships, and those are rights that exist in the frame of justice, this first understanding of use, which later generations then translate as morality. And then the ideological point, what are we here for? We are here to realize those subjective rights. The actions of each individual and the use of his possessions were made subject to not another's will, but to his own. So this is where the first part, in a sense, ends. There are a series of legal languages, Roman law, theology, especially the secunda secundae, the second part of the Summa Theologiae of Aquinas that deals with virtues and especially the virtue of justice, and then a specific understanding of justice that Grotius, a set of specific understandings produced by Grotius. The second set of chapters that go through France, Britain, and Germany. Of course, there's a lot of text there, so I just say something on each. So about French absolutism, I make the point that at the very moment when Louis XIV one morning wakes up and thinks, l'État c'est moi, at that very moment, a correct response to the question, what is France, would be, France consists of something between 50 and 60,000 venal office holders, men who have bought their way into the office and hold that office as private property to the extent that it is inheritable by their eldest sons. So Louis could not lift a finger without having to operate with this oligarchic arrangement of private property rights over what then presents itself as France. Famously, he was completely tied by the financiers, the financiers which were often paid by creating new state positions, which they then used in order to enrich themselves. Now, there is a duck and rabbit image here. France, absolutist state, or mafioso arrangement between ruling families. Another French context is obviously the revolution, where two types of vocabularies are put into new use. Sovereignty, the vocabulary of sovereignty goes to the use of nationhood, the sovereignty of the nation. Abbé Grégoire, one of the leaders of the revolution, even proposes to the National Assembly the passing of Déclaration des droits des gens, a declaration on the rights of nations, which would follow the Déclaration des droits de l'homme et du citoyen. But because France was at the moment engaged in war with everybody around them, the assembly didn't think it politic to pass that declaration now. So I look at the re-articulation of sovereignty in nationhood, but also the destruction of the feudal system in France and the debate that ensued in 1792 and 93 at the time of the terror, and especially what Robespierre had to say about the reconception of property right in what we would now call a social set of privileges that human beings had. Robespierre had a formulation for the new constitution that would have defined property from the perspective of its ability to create welfare for the nation itself, and would have entailed the ability of the nation to redistribute property, if the case may be. Of course, then with the Civil Code 1804, none of this became a reality, but we have the kind of property which then spread in the 19th century elsewhere too. In Britain, perhaps the best way to try to demonstrate what I try to do with those three long chapters is to reference the ship money case from 1637. This is in the run-up to the English Revolution. Charles I, who uses state funds for various dubious purposes, finds himself without money. So he decides on the establishment of a new tax, the ship money. And he argues in the parliament that the Dutch are going to intervene Britain any moment, England any moment. And because there is only a tax for shipping that exists for the seaside cities, the cities that have ports, we now need to tax the whole of England, all of England, so that we get the money in order to build a fleet that's able to prevent Dutch intervention. Now, everybody knew that the Dutch intervention was a scam. There was no real danger of that, and that Charles needed the money to pay his debtors and to lead the kind of life that he had been accustomed to. And a number of noblemen refused. And so he jailed them. The result was a legal case in the Court of Exchequer, the ship money case. In the ship money case, the king argued, and of course, this is the Court of Exchequer. It's one of the prerogative courts. And King's representative, Sir Edward Littleton, argued in the way that you can see here, that the public and the private are so nearly connected that they can hardly be separated. The public loss falls immediately upon particular persons. It's impossible to save private fortunes if the public be lost. Now, here, Littleton and the court re-articulates the royal prerogative. The royal prerogative, which is the English vocabulary through which English, not only the court, but England in general, defined its relationships to outside. As Sir Edward Coke famously said, the common law doesn't travel abroad. So it's useless in articulating relationships that we would today call international. The fear of a Dutch intervention is an international, or has to do with an international relationship. Ergo, the royal prerogative applies. And does the royal prerogative extend to taxes without the consent of the parliament? Now, the parliament and the lords obviously say, no taxation without representation. And the king says here, that look here, your properties are completely dependent on my ability to protect them. It's my task under the royal prerogative to protect you. Therefore, your properties cannot have an independent existence from my foreign relations power as articulated under the royal prerogative. And that's Leviathan. So Hobbes makes exactly that point. Private properties are completely dependent on royal sovereignty. Property depends on sovereignty. And that's exactly the contrary point that Locke makes a few decades later in the two treatises of government, when Locke asks or creates the idea of a social contract between property owners, famously in chapter 5 of the second treatise. The Commonwealth is created as an outcome of a contract between property owners. Sovereignty is the creation of property owners, and the property owners have a constant right to control the uses of the sovereign power by the one who has it. So exactly the same argument in two directions. So in lengthy chapters, I examine that. In colonies, I have a chapter on the French colonization and in the English colonization, and both of them, those chapters concentrate on the great difficulty of talking in terms of sovereignty rights or property rights in the colonies. Many people don't know this, but Richelieu was a great colonist. So at the time of Richelieu, around 50 colonial companies were established. Richelieu tried originally to hire Grotius as his legal advisor, because Grotius was now a refugee in Paris, and everybody knew Grotius was a famous man and that he had been the legal advisor to the Dutch East India Company. But Grotius declined. But he nevertheless had several interviews, and Richelieu learned the system of colonial companies that the Dutch had used. And so he, for instance, in the Compagnie de Saint-Associés, which then eventually becomes Compagnie de la Nouvelle-France, which then eventually is donated powers to rule from the Arctic Circle to Florida. So not an insignificant part of the world in this sense. So the associates of the company receive this territory, as I said, eventually from the Arctic Circle to Florida, en toute propriété, justice et seigneurie. And if you ask the question, well, did the company receive property rights or sovereignty rights? It's impossible to respond to that, of course. And then I tried to examine the various situations in which that attribution is then operated either on behalf of the king, on behalf of the company, or on behalf of the rival companies, because the merchants in northern France who were not admitted among the Saint Associés obviously had things to say about this way of acting. And the Virginia Company likewise. I remember very well when a decade ago or so, I came to the charter of the Virginia Company for the first time, and I was confronted with the language that the powers of the company are defined in this way, that the power shall be holden of us, James I says, our heirs and successors, as of our manor of East Greenwich in the county of Kent, in free and common soccage. I think that's how it's pronounced, or sausages. It's and not in capitem. When I came to that, I thought, well, this is it. I'm not going to pursue this. I'm going back to diplomacy. I have no idea of what this means. But of course, then many people have commented on it. And later on, in later charters, the king gives more language about it. And so in the other quote is from the second charter from 1609, where what is being granted to the company is full and absolute power and authority. In this way, as you can see, the company can establish courts to try Englishmen. Now, at the time, this jurisdiction was not understood to cover the native inhabitants. The English chapters end with the end of English rule here in the New World. Adam Smith famously was an opponent of the colonization of America and suggested that why not just trade with them? That's the interest we have. And one of his successors or his ideological supporters was Thomas Pownall, who was the governor of Massachusetts. But when the revolution then started, Pownall returned to England and wrote a series of commentaries on the ongoing war, supporting the positions of Adam Smith in those commentaries. And he suggested, and in London, intellectuals debated the proposal that there should be a new system of rule. And I quote here from Pownall's writing what the suggestion is. He suggests that European sovereigns should sit together in a great conference to establish a perpetual council and a seat of judicial administration to rule over the world. And the point of that rulership would be to set up chambers of commerce across the world, in America, in Asia, in Africa, all over. And this council would then rule it. And he predicted something quite inconceivable, that America will then be the arbitress of the commercial and political business of the world. So there were, in this story, there are many ways in which people use their imagination to think about the possibilities of ruling the world differently from how the world then came to be ruled. And I'm really interested in those avenues not taken at that moment, and especially not taken at that moment, but still alive in our period. So I come to the 19th century, and I try to make the argument that for many powerful actors, there was no law of nations at all. There was only imperial power, from the famous Don Pacifico case, where Lord Palmerston says to the Parliament that every Englishman, wherever they may be, must be able to think of themselves like the Roman citizens at the time of Roman Empire. The strong hand of Britain will always support them. And the case is very, very famous. I don't want to go to the details here. At the same time, in America, Joseph Story was writing his commentaries on the conflict of laws, despairing over the fact that there doesn't seem to be any law among countries. And that indeed, without a general rules of right and obligation, things look pretty grim, because the sanctity of contracts and the security of property, which is his concern, are not being respected. In a few passages below, he then says, well, actually, things are not that bad, because in all countries there are courts, and that there is a kind of a general mercantile law. I avoid using the word law merchant or lex mercatoria. I deal with that elsewhere, but that's a really contested set of contested terrain, so I don't want to go there. I just make these points in order to say that from the perspective of London and Washington at the middle of the 19th century, the situation was really unclear, and that but that domestic laws and even British imperial and colonial law could fulfill what otherwise might be a vacuum. The last substantive chapters are about Germany. As I said, they are about German academics, to whom I also have immense admiration and belong to the very, very tiny minority of people who actually has pleasure in reading these thick volumes, like the one by Johann Heinrich Gottlob von Justi, which is I didn't have the main page. So this is now, we are in the 18th century. The 7 Years' War is underway, and France is losing. France is losing because the British are able to sink French vessels going to Saint-Domingue and to other provinces from which France then has been in the habit of importing sugar and spices and other stuff, which it then exports and collects funds. The French are outraged because they don't have a similar navy, and they send their ambassadors to especially Berlin to speak to the Prussian King Frederick the Great, trying to convince Frederick the Great that what Britain is doing is illegal. In war, you are not entitled to sink merchant ships of your adversary, and France suggests that the idea of balance of power should also be understood rightly to be what they call balance of trade. So they use this expression for a slightly different way. So there should be a balance of trade. You are not entitled to disturb it, and what the British are doing, they disturb it outside the operations of legitimate warfare. Now, Johann Heinrich Gottlob von Justi, who is a natural lawyer trained in Göttingen in the wonderfully active and imaginative context of political realists and idealists, etc., in the natural law field. Justi is one of these lawyers who acts as a legal counsel early on in his career in Vienna for the emperor, but then burns his bridges for obscure reasons and tries to get a position with Frederick the Great in Berlin. And in order to have this possession, he writes this book, Die Chimäre des Gleichgewichts des Handlung und Schifffahrt, the chimera of balance of power in trading and shipping. And in this work, he makes an extensive argument, the point of which is to say that a balance of power is all right if you think in political terms. So you can measure the political power, the military power of countries so that you can measure whether something is in balance or it isn't. But trade is different. Trade by nature is global. You cannot limit countries' ability to trade through a legal enactment, because that limit doesn't only hurt the country that is at war, but also its trading partners, who are innocent third parties in any conflict. And he suggests that we should think of the political and the economic as wholly different realms, which have their different laws operating with it. Vattel, of course, is the balance of power person. Justi, who uses the balance of power in order to separate politics from economics, then acts as an inspiration to Georg Friedrich von Martens, who in Göttingen starts a new way of teaching what he calls droit des gens modernes de l'Europe, modern European international law, that no longer deals with trade and commerce for the first time at all, in which Martens actually imagines into existence something like diplomatic law. He imagines that diplomacy is law, and he does it in a very concrete way, scandalously. In his classes, he starts to, in the afternoons only though, he starts to speak in French. And for the boys who are there, he distributes to them papers and tries to teach them to write diplomatic acta in French. And he takes his best research assistants and uses them to collect diplomatic acta from other countries and starts to publish what then becomes the Martens Recueil, the Recueil de Traités, which then develops into the League of Nations Treaty Series, which then develops into the United Nations Treaty Series. And for the first time in this book, first in its Latin version, then in its English version, then in its many French and German versions, imagines that there is a public law system in operation, which is what diplomats administer, in which state treaties are understood like contracts, etc. And the last person in this prehistory is Georg Friedrich Hegel, who takes from Martens, that's my supposition, I haven't yet been able to prove this, but I think that can only be true, takes this new vocabulary of äußeres Staatsrecht. So when Martens imagines diplomacy as a kind of management of a legal system, he uses in the German version the expression external public law, äußeres Staatsrecht. And when Hegel then sketches the relations between states, he's quite confident in sketching that in terms of äußeres Staatsrecht, and he juxtaposes that world to the world of modernity, which he sees to be cosmopolitan and totally international, in which he paints already in dark sociological terms, we would say, the industrialization, the first steps of industrialization that he sees, the impoverishment of the masses, the global trade, which extends over this very limited sphere of external public law. And my last slide is my epilogue. And the epilogue looks at the 1848 revolution. And I now have the sense that that's an underappreciated moment from the history of internationalism and international law. And I tell the story of Robert von Moll. Robert von Moll is the professor of public law in Heidelberg before the 1848 revolution. He's reasonably famous, and he's a liberal. When the German Revolution then takes place and the parliament of the short-lived German Republic meets in the St. Paulskirche meetings, von Moll participates, but not only participates, but becomes appointed the justice minister of the German Republic in 1848. As he is in Frankfurt, his position is filled by Johann Caspar Bluntsch, this person over there, a liberal who is a refugee from his native Zurich. He's a Protestant, a conservative liberal, one could say, but because of the religious disputes, among the Swiss, he needs to leave Zurich, and he ends in Heidelberg. And he takes up the teaching that von Moll had. Now, of course, the German Revolution ends in a bad way. Many of the revolutionaries become refugees across Europe, in Britain, in Switzerland, and so on. Remarkably, von Moll, who was a famous public lawyer, maybe the most famous public lawyer in France at the time, is able to capture his chair in Heidelberg again and writes two things. One is he writes a law of nations, a long law of nations report on the right of asylum. Now, we might understand why he would do, because all of his friends are applying for asylum all over the place. But more importantly, then he writes a couple of articles, long articles, on this idea of an internationale Gemeinschaft. He suggests that it is a new time now, and that people are traveling across nations, trade relations are being intensified, trains start running between nations, etc. Societies, informal societies, are being created inside states, and that there must be a realm of human existence between the existence within the state and existence as an individual, which he calls Gemeinschaft. And he suggests that this Gemeinschaft doesn't know boundaries, that it moves softly from one place to another, and he calls this the internationale Gemeinschaft. Gemeinschaftlichkeit. Now, the idea of Gemeinschaftlichkeit is received by von Moll from France, and through another public lawyer, a young socialist public lawyer at this time, Lorenz von Stein. Lorenz von Stein is known of having been the young German who was following the 1830 revolutions in Paris and was impressed by what he saw, and was impressed by this language of the social that later on in the century then led to what we call the social question. And von Moll, in his footnotes, takes up the reports that Lorenz von Stein writes on the French 1830 revolution and translates that into a language of German public law, into this idea of Gemeinschaftlichkeit. Bluntschli, meanwhile, and so fortunately both of these men, Moll and von Bluntschli, have written autobiographies where they have interesting passages on each other. They write respectfully, but it doesn't require a lot of interpretative skill to realize that they are of completely different men, and their interests and alignments are completely different. So Bluntschli, in a polite way, attacks this idea of Gemeinschaft. What's that? There is no such thing. It cannot be given a legal expression. It's some vague notion that exists in France. And instead, what we have is civilization. Civilization is what unites us and which makes us Europeans what we are. Now, in my previous book, The Gentle Civilizer, I tell in more detail as to how the idea of civilization then, through Bluntschli's writings, gets into the statute of the Institut de Droit International, which is established on the 8th of September, 1873, after lunch, and in which the Institute defines itself as the juridical conscience of civilization. And I suggest, this is where I will end, I suggest that there was a moment after the 1848 revolution when two vocabularies, legal vocabularies, competed with each other and tried to push from the nation state towards something larger, namely the idea of Gemeinschaftlichkeit, society, and the idea of civilization. And at least for international law, it's clear which came out as the victor. Okay, I'm sorry I've taken a lot of time. We do have still some time to discuss. Thank you.